Hey everybody, Todd Vandermide back for another edition of Freedom Steel, and we've got a good giggle snort kind of moment out of the trial today. So more about that after the intro. Hey guys, welcome back to another edition of Freedom Steel. Todd Vandermide, former NRA contract lobbyist, Illinois gun law guru, the gun Santa over on Reddit. And today was day 2 of the trial on whether or not Illinois' gun ban is constitutional. And so today was dedicated to a witness for our side who his name is Ron Kanan, who used to be the head of development for the Remington LE and DOD divisions, and then later took over consumer consumer Overwatch, Bushmaster, and DPS. Uh, and so with that, there was a lot going into his background, his credentials, all that kind of stuff. There was a lot that went through the processes to show how firearms made for the military are built in a different product line. They're built in a different fashion. Their tests, their specs are way different, all that kind of stuff. And it was a good day. I think that for our side, we have to go through this minutia. And I know Mark Smith over at Four Boxes Diner says we don't need experts. And generally, I would agree with him if we had courts faithfully applying the Bruin and Heller tests. But we have the Seventh Circuit Court of Appeals who has said there's this new test of military arms, and military arms do not qualify as arms under the text of the Second Amendment. That's a whole nother video about how they're trying to redefine what the court has already put down. But with that they're trying to, they said their mind could be changed possibly if there was certain evidence or whatever that was offered at trial. So we have to bring in experts that deal with these kinds of issues to give the judge the ability to do the reasoning and looking at the facts that the Seventh Circuit has says they want to consider as the Court of Appeals. It's all bullshit on the Seventh Circuit's part, just like the Fourth Circuit was full of bullshit when they wrote the Bianchi decision. And here's hoping that the Supreme Court takes Bianchi on cert and puts an end to all this nonsense. But so we had this long testimony today, lots of questions about his qualifications as an engineer, the projects he ran, the things he was involved with, specifically like triggers. He helped design the 1187 program for Remington, so on and so forth. Really, I mean, this guy is a number one engineer that knows the firearms industry and knows the procurement process for DOD, all the like. And so we got through all that, then took up to lunch. There was some questioning on our side after lunch to kind of wrap a neat little bow around this whole thing. All went well, talking about how the thumb hole stock or whatever on a shotgun doesn't change a lot. Talked about how these guns are used in competition, they're good for self-defense, whatever. And the state is sticking to their argument about self-defense, which leads us into the most, this thing's, if this was just done on the internet, then somebody broke the internet. And if you know what my hashtag for these idiots on Twitter is, then you're going to get that this is one of those hashtags. And so during the cross-examine, the state was trying to drill into the difference between military specs and civilian firearms when considering things like trigger pressure or what the pull of the trigger is going to be. And for military guns, our expert said that the amount of pressure it takes to pull the trigger is higher. It's around 6 pounds, could be as much as 8. And it's there designed to make sure that every trigger pull is intentional to make a negligent discharge that much harder. And he said that, for civilian arms, trigger pressures factory could be as low as 2.5 pounds. Now, we all know there are some triggers that are way lighter than that. But then the lawyer for the state, in an absolutely straight face, asked if that meant with a 30-round magazine, it would take 90 pounds of pressure to fire the firearm. Yep. She wanted to know if that in the course, she's trying to do this cumulative addition of 3 pounds per trigger pull times 30 rounds in a magazine means it's 90 pounds of pressure. And evidently there was some sort of thought in her wayward mind that that's 90 pounds and that it's going to cause some sort of fatigue or something. I'm not quite sure. This is not a compound bow. This is not a long bow. This is, and she allegedly pulled something like this off in the deposition of this expert, trying to equate that the impact energy of a bullet, you could say, so let's say that a 5.56 round is going to hit with 500 pounds, foot-pounds of energy at X distance, that if you multiplied that by 30, you were getting hit with that number. No, it's not cumulative. It's each individual. But yes, she wanted to know that if it would take 90 pounds of pressure to fire a 30-round magazine from a civilian firearm, I don't know what to say. I'm speechless. There are 5 of these lawyers for the state that are at their table with some support staff, and then they went on to try to assail the character of this expert based on the fact that since retiring from Remington, he has done consulting work in litigation cases for the NSSF. He has made a fair buck doing so because of the pedigree and the credentials that he has. And they tried to assail his character based on those things. You haven't worked at Remington since like 2017 or 2018 when he retired or whatever. Yeah, okay. That's the best you have in this. So all in all, day 2 went well for our side in my book. We are giving the judge all the information the 7th Circuit says it needs. Now, I think I will agree with Washington Gun Law and William Kirk that it is likely that we will win a judgment at the trial. I think it is possible that the judge may issue a stay depending on how the appeal is or how he writes his decision. And then that the 7th Circuit will issue a stay if he does not hold his findings back and issue a permanent injunction on the spot. And then we'll be back up in front of the 7th Circuit. Now, Viramontes has had their filing deadline for a reply brief pushed back to the 18th of October. So if everything goes right, the trial should be done Thursday. And then there will be a little bit of time for some briefs. People are going to be checking transcripts, making final arguments. We'll see how all that goes. But we should be wrapping up tail end of this week. And I'll keep you informed about what I hear is going on inside the courtroom. We had to come back home. We have some other obligations this week. Could not find somebody to watch the dog all week, and I got some other stuff I got to do. But with all that, so thank you. That is it tonight. So if you think that one just might break the internet, You never know. But as always, thank you for watching. Hit that like, subscribe buttons. Sit there and copy and paste the link and share it around all your social media and friends. And as always, frag out.